verdict versus the judgment.
Yes, and if you'll give me just 1 second, I will put that up because I've got that. Hold on 1 second. Okay, so let me scroll down to we're talking about. Okay, so here is the question that was actually asked in question number 3 in the charge. Let's see. Yeah, there we go. So what is the redemption price for Judith Richmond's 1/3 partnership interest in the Richmond Trust Partnership? Can you see?
I can see it. Great.
Okay, great. And that is actually reflected in paragraph 7 of the judgment, which you can see here, is therefore ordered, judged, and agreed and decreed that in accordance the fair value for the 1/3 partnership interest is that number. So what we're saying is that paragraph 7 does accurately reflect. We don't have a problem with the jury verdict on this point. What we're saying is that paragraph 7 accurately reflects the jury's verdict. Paragraph 8 does not. It is something that is not what the jury was actually asked and is awarding something that the jury was not asked to determine. And so that's the issue that we have here. That paragraph 7 is correct. It does actually.
You're wanting us to modify paragraph 8 and remove it. Is that it?
That's correct, Your Honor.
Okay.
May I respond, Your Honor?
Yeah.
I believe paragraph 8 should be deleted.
I understand that.
Yes.
Mr. Tobolowsky.
Okay. If I can share, Mr. Fair, if you don't mind pulling your screen down so I can share mine. Thank you. Okay. Excuse me. I've got a little PowerPoint as well, Your Honor. I'm going to go directly to the right slides. Okay. So I believe the court can see. If the court cannot see the screen, let me know. But so this is the question in full. And excuse me, I'm going to jump to the actual rule of the cause of action that both the plaintiffs and the defendants filed. And the rule specifically is about the terms of the redemption, not just about coming up with the value. And so, for example, it states under subsection C, the court shall determine the terms of redemption.
Subsection C of 152.609 of the Texas Business and Organizations Code.
Correct. Thank you, Your Honor. I apologize. Yes,
okay. I just want to make sure it's clear on the record.
Right. And that is the relevant section that both plaintiffs and defendants filed claims to determine the terms of redemption under. Furthermore, the question, what is the redemption price for Judith Richmond's 1/3 partnership interest? If what the defendants are arguing was correct, and that this has nothing to do about what's owed and therefore what needs to be paid, then it begs the question, why throughout the whole trial, and this is the portion of the trial transcript from closing argument, where Ms. Compton is telling the jury, because the redemption amount has been paid in full, we ask that you put 0 on that amount. So now today in court, apparently they're stating they don't disagree with the number, which I won't waste the court's time because I know the court's read our responses, but it shows that the evidence is in the record to 100% support the calculation that the jury did to come up with the number that they answered in response to question 3. And it wasn't until after the jury came back with that determination that all of a sudden we started hearing from the defendants, that's actually not what that question means. In fact, after the judgment was entered, Ms. Compton sent an email stating that apparently what the jury found was that RTP substantially overpaid the redemption value. And therefore, according to her at that time, the jury's verdict somehow meant that we owed the defendants money. I think it's clear, Your Honor, that the argument that's being presented to the court is an attempt to undo the jury's finding. But the law, the facts, and the evidence in this case all support the final judgment in the exact same form it is in right now. And again, I have countless other slides to further prove up this fact, but I know the court's got a lot of other things on its docket, and I don't want to waste time.
Mr. Fair?
Yes, Your Honor, and if I may have the screen back.
Sure.
Sure, thank you. So the issue really is not just, what does the law allow for, but it matters what they actually pleaded for and what the jury actually answered. And I understand that he's saying, well, the rule allows them to recoup money for if there was an overpayment or an underpayment. But that isn't actually the question that was asked of the jury. The jury was asked, what is the redemption price? And the redemption price at the date of her withdrawal, in other words, her death in 2008. It wasn't asked how much has been paid since then. It wasn't asked how much is owed now. It wasn't asked any of those things. And so, what we have said, and we agree actually with Mr. Tobolowsky that the jury calculated that correctly. They took the right information as to what the value of the partnership was, and they pulled out the stuff that was the properties in dispute, and then divided that by 3 and came up with the $228,000 number. That's correct. That's the value of the partnership interest as of 2008. That has nothing to do with how much money is owed today or not. They never asked for that. They never asked for that in their pleadings. They didn't ask the jury that in this question. That is their question they submitted. They asked for the jury to determine what the redemption price was in 2008. And, it's the same thing. Well, what is the mortgage on my house? Well, I had let's say I had a $300,000 mortgage on my house when I borrowed the money. But does that mean that's what I owe today? Well, I've made payments since then. I've actually sold the house since then, so I don't owe anything on the mortgage. That's the idea here. Ms. Compton was correct in saying that she did not owe, or that the partnership did not owe any further money on the redemption amount because it's already been paid. But in essence, none of that matters for a jury verdict and for a judgment on the verdict. What matters is what was the actual pleading in the case, what was proved, and then what was the jury asked and what did they answer. There should have been a question, something along the lines of, what amount do the plaintiffs owe today for the redemption price? And there was no such question. There's also nothing in their first amended original petition that asks for damages. And I've got a chunk of that particular cause of action here on this slide. That particular cause of action only asked to determine the fair redemption price as of August 28th, 2008. So, you can't have a judgment that awards something that wasn't pleaded, that wasn't asked of the jury, and that has been added on after the fact because Mr. Tobolowsky has assumed that, well, this means that I can then get that money now. That's not how this works.
Your Honor, if what Mr. Fair just said is true, I don't understand why Ms. Compton was telling the jury to answer question 3 with the number 0. Surely they are not valuing Judith Richmond's interest in the partnership as $0. They asked for 0 because that was the issue. They are trying to reframe the issue now. Otherwise, there would be no purpose to the TBOC section that we just looked at when I shared my screen. The whole purpose of that section and the cause of action is to determine what is owed to redeem a party's interest. And if the defendants now have a problem with the wording of the charge that was given to the jury, honestly, Your Honor, that's their fault. They were okay with the charge to the jury when they thought they were going to get a 0 in response to that question. So I think at the very least, they've waived the ability to make this argument now and should also be judicially stopped from doing so, given that they stood up in front of the jury and made that whole argument. Otherwise, we are essentially filing a lawsuit, litigating it we've litigated this one for 3 years, only to now, I guess, go back to court to have round 2 of a lawsuit to determine what is still owed. It just doesn't make sense. It wouldn't make sense what the legislature was intending with that.
I will tell you, Mr. Fair, you weren't there for trial. That was my understanding of what we were litigating. If there was some error that wasn't brought up at trial, I'm not aware of it. But is there any case law that supports your interpretation of this, that you need to get a separate finding in order to have a judgment as for this?
Well, okay. So, I mean, first of all, there's not any case law interpreting that particular section of the BOC. But in terms of, can you get a judgment for something that wasn't pleaded and wasn't asked? Yes, absolutely. And we've cited that in our briefing. I mean, I'm happy to pull that up and
no, that's I mean, that's obviously.
I'm sure you can look that up.
Right.
The point here, and I mean, yes, I was not present for the arguments, but arguments don't matter in terms of entry of a judgment. Entry of a judgment on a verdict has to do with what was pleaded, what is in the evidence that was presented, what the verdict actually says, and tying those things together. You know, one other point I need to just get to, and that is, it's not our responsibility to present the correct questions to be asked to the jury on plaintiff's claims. It's their job to do that. And if they didn't ask the right question, we don't have to object. We don't have to do anything. They have to ask the right question in order to get the right answer, in order to get the verdict that they want to get. And
I will admit, Mr. Fair, that's a very
different.
It's a very clever argument. I'm not saying you're wrong. It concerns me that we litigated this the whole time and no one ever raised this issue. Mr. Tobolowski, do you want to agree with Mr. Fair and amend it, or do you want to let him take this up and fight it out the way?
I think I'm perfectly content with him taking this up. Again, I was supposed to have my appellate counsel here today too, who's been working on this with me, Jeremy Martin. He's tied up, but we're very confident in our position and are prepared to defend it. And just to clarify, it was pled. It is in our First Amendment petition. It is cited, I believe, in both our live petition and the defendant's live counterclaim under the same statute, referencing this statute as being the claim. It's just a unique claim that doesn't get litigated often, which is perhaps why there's not a lot of case law on it. But again, it was clear from day one what we were arguing and what the issue was and what was presented to the jury.
Well, Mr. Fair, you may turn out to be right on this. I hope you're not, because then we just wasted a bunch of time. But I'm going to go ahead and deny the motions, and I appreciate you bringing these to my attention. So have you submitted an order as this, Mr. Tobolowski?
I need to double check. I don't believe I have. I'll get one submitted immediately, Your Honor.
Make sure you share that with Mr. Fair and Ms. Compton before you get there. I don't know if I was given these instructions back when you were actively involved, kind of before you were sick, but April 20, make sure you include at the beginning of the order, it says April 25th, 2022. Make sure you share it with Ms. Compton and Mr. Fair, and then try to get it to me as soon as you can. Email it to Rhonda as well as e-file it. Okay, guys?
Will do, Your Honor. Thank you, Your Honor.
Thank you, guys. You have a great day, okay?
You too.
Thank you, Your Honor.
Thank you. All right, I think our next case is on the Moss v. Princip case. Anyone here on Moss v. Princip?
Yes, sir. We're here.
Okay. All righty. So I know that you guys wanted or Mr. Hurst, is Mr. Hurst here? I know he wanted a record on something. I don't.
Yeah, yes, Your Honor.
So let me go on the record. So
sure. Thanks.
we put everything on the record that you
Sorry.
on the record. I apologize. So let me go on the record on cause number DC 209893, Moss v. Princip. Council, make your appearances, and then I need to say something before you say anything else.
Royce West, Craig Capio with Dan Wide for the plaintiffs.
Michael Hurst, Jervon Newsom, and David Cole here on behalf of non-parties Google and YouTube.
So I want to just make a note that Ms. Bone and Mr. Martin were notified of this hearing earlier today. Apparently they may have counsel that they've hired, but this person, they filed a motion but haven't entered an appearance. They were not here for the hearing this morning, or not here for the rescheduling of this hearing. And so I just want to make that clear on the record. Also, just so I don't forget, there's been a request for findings of fact, conclusions of law from this attorney who's apparently made an appearance. So I would like Mr. White or Mr. Capio or Mr. West, if you guys could prepare proposed findings, and if you haven't already, proposed findings and conclusions of law, findings of fact, conclusions of law. Share those with opposing counsel, including Mr. Hurst. He may have some good suggestions on how to clarify this, and then as well as Ms. Bone and Mr. Martin, and if this new attorney ever makes an appearance, with them as well, and then get those to me in an electronic format as well as the format I'd said before. Okay. So let's go to the subject of the issue today. And Mr. Hurst, I think you wanted to put something on the record. And
Before Mr. Hurst puts something on the record, we need to get an extension in terms of the brief that we're supposed to be filing. It'll be Friday before we'll have the brief that the court requested. And when Mr. Hurst finished, I want to revisit the order that the court is looking at today briefly.
Okay. Mr. Hurst, do you have any opposition to that change in the briefing schedule?
No, I think if Mr. West would have confirmed with me, I would have absolutely agreed to that. Yeah, not an issue there.
This just came up.
Okay, sure, absolutely, of course. I'm sorry, Royce, you finished?
Yeah. Well, let me, if the court pleases, Mike, if you don't mind, Mr. Hurst, let me go first, because you'll probably have some comments about what happens.
Absolutely fine. And you can call me Mike. That's fine.
Judge, this court held a hearing and granted the plaintiffs $389,000 plus prejudgment.
We had a trial. Yeah, we had a trial. Yeah, you said we had a hearing, and there was a full-fledged trial. They had an opportunity to have a jury, and they waived their opportunity to have a jury.
Yes, sir. And then subsequent to that, you were considering a request by the plaintiffs to distribute some of the monies that were in the court's registry. The court indicated that it would distribute monies only as it related to the liability concerning the house in Collin County, and said there was going to be $389,000, asked us to submit an order, and that the court would grant us $290,947.46 of those dollars, and ask us to prepare an order. We prepared the order, and the court has not considered that order. In addition, you said that there would be another $98,000.
So there's two different issues here. There's one is depositing in the registry of the court. I think that's right. What I said is the I've signed that order to deposit that money in the registry of the court.
Right. Then I was
the question is dispersing the money, and that I don't believe we'd had any.
And there was a hearing where and that's why I'm trying to refresh the court's recollection. There was a hearing on that, and you said that you would disperse the $389,000 as it relates to the liability associated with the fraudulent conveyance of the house, and that you ordered that $290,947.46 be distributed to the plaintiffs, and ask us to prepare an order so stating, and we did. And the court.
Right. If I said that, let me do this, Mr. West. I'd like to hear from Mr. Hurst, or really, I'd like to hear from Mr. Cole. On this is kind of an unusual situation where you have the history here, to say the least, is unusual. And so we're at a point where we have money in the registry of the court. There's still the possibility of an appeal. And I'm not sure if we should go ahead and distribute it now or wait for see if they're going to file an appeal or kind of what we're going to do. So I'd like to hear from Mr. Cole or Mr. Hurst, but preferably Mr. Cole, on his thoughts on that as our resident appellate expert.
All right, David will address that. Afternoon.
I just want you to discuss that one issue, is that when would it be appropriate to disperse this money?
Well, I don't have a precise legal answer. I only have practical ones. The reasons why we have raised objections to this have to do with the potential copyright issues that pervade everything we've been talking about in the post-judgment proceedings here. And it seems to me that breaking off this piece of these orders and these proceedings and ruling on it earlier when the court is still receiving briefing about the underlying copyright issues is not the most efficient way to go about it, and we might ultimately learn it's incorrect when that briefing has continued. As Mr. Hurst has said repeatedly, this is not our fight. We don't have a dog in it. We just want it done right.
Mr. Cole, you're kind of yelling. If you could maybe, I don't know why you're so loud, but it feels like you're yelling.
It's the passion I feel for the law, and how excited I get about things like YouTube accounts. But I'll toning that down a bit. The efficient way to do this is what we set out to do a week or so ago, which is have one set of briefing that includes all these issues, and then we move. I think the worst outcome, if the Court of Appeals examines this, would be that we received all the briefing and realized something shouldn't have been dispersed that already had been. It's near impossible to get the genie back in the bottle at that point. And that's all I have to contribute on that point, Your Honor.
Well, let me ask Mr. Cole. Wait, Mr. Cole, you're not released yet. I know I'm not an appellate court justice, but you still got to listen to me, okay?
I just wanted to show off my cool wheels there.
So my big issue here, this is why I'm struggling with this, to be honest, is I feel pretty comfortable, and I have not asked for any briefing on the issue of the wrongful fraudulent conveyance of the house. I think it was clearly wrongfully conveyed. I think there's no question in my mind that was correctly decided. Now, the Court of Appeals could disagree with me. I don't need additional briefing on that issue. Is it appropriate for me to go ahead and disperse the money in the registry of the court before the judgment becomes final, or what? That's the question in my mind I'm struggling with.
Here, I think I see the same issue. Here's how I would describe it, which is, I think the court is right about well, I can't really say right or wrong. The court has had all the evidence presented to it about whether a fraudulent conveyance occurred. The issue with these funds, though, is where they came from. And the potential copyright issue that concerns us is, what if the money that came in from the operation of these accounts, these videos, these channels, is not in fact something that we should have control over and this court have jurisdiction over? The connection between the court's fraudulent transfer judgment and the source of these specific funds, I think, is the potentially problematic point, and the reason why I think that briefings should unfold on that underlying issue for all the ways it comes into the issues in this case.
Judge, with all due respect to Mr. Cole, these funds are separate and apart realistically from the issue of copyright. Okay, this court ordered disbursement of the monies, which are AdSense money, not copyright money. They're in the AdSense accounts, and the court has already determined that there was a fraudulent conveyance of the house. So that's a property issue. Now, that's even accept the issue that Mr. Cole is talking about in terms of copyright, and that's what the court asked us to brief on copyright, not disbursement of the funds. The court's already looked at, and I understand the court has to make a decision and weigh everything that you have before you, but it's real clear that there was a fraudulent conveyance of that house, real clear, and that there's money.
I 100% agree with you on that.
And there's money in the court registry that can help satisfy the underlying judgment, realistically, not only this case, but the one in federal court that the plaintiffs have been able to get. So obviously, we need to make certain we're able to get sources of those particular funds as a result of the judgment that's been entered.
All right. Mr. Cole, let me ask this, Mr. Hurst, this is for Mr. Hurst. How much money does YouTube have?
You mean how much has been frozen so far?
How much has been frozen so far?
I had that number at some point. It's several $100,000.
Well, Judge, at all due respect, you asked Mr. Hurst to get you that number. I think it was last week or week before last.
Yeah, let's see if he has it. He probably does.
I can look it up and get the exact amount. I think it's somewhere around $400,000 that has been frozen per prior orders from the court.
400,000 in addition to the money already in the registry, or
I believe that's correct. It may be a little under 400,000, maybe 300 and something thousand. But I don't know the exact amount, but I can try to get that if you want to hold on a minute, or we can. Yeah. You want to get that for you now, or you want to proceed on?
Your Honor, can we go and get that now? Because I mean, you've been asking for that for the last 2 or 3 weeks now. And it's my understanding that there's, and correct me if I'm wrong, Mr. Hurst, that there's 300 and how much is currently in the court's registry? Plus,
I'm not sure how much is. I'm not sure how much is. Does anyone?
290,000 and some change.
How much? What did you say?
I said 290,000 and some change.
Okay.
And the court had asked for, frankly, an accounting of not only the money that's in the registry of the court right now, but how much other monies are being held, the other money is being held by Google. And we still haven't been able to get that number.
It appears it's somewhere, it looks like it's somewhere north of $400,000, Your Honor, perhaps even north of $450,000
of additional money.
And again, I don't know if the monies that are already in the registry of the court are the same, if that's enough money relative to the fraudulent transfer of the real estate. I think Mr. Cole's and my concern really relate to not whether or not that was a good claim or not. Again, we have no idea.
I'd all due respect.
Royce, I'm sorry, excuse me.
Mr. West, let him finish. Let him finish.
I think the only concern is where that money came from. The distribution of it right now, I think, again, I would just reiterate what Mr. Cole said is the money isn't going anywhere, right? I mean, you've got it in the registry of the court. It's not the amount of damages, it's the source of where the revenue came from. The revenue came from the video content that was posted on the YouTube channels, that was generated by the YouTube channels.
So this is what I'm going to do, unless there's a strong, Mr. Cole or Mr. Hurst has a strong objection to this. This is, it's going to be a little bit of split the baby here, but I'm going to go ahead and sign the order to disperse this within 2 weeks. So get the money in the registry. We're going to disperse the whatever it is, $398,000 in 2 weeks, and give if the defendants want to file a mandamus during that time, they can file a mandamus, or if I prefer if Google didn't file a mandamus, if there's something that they have a concern about, I'd like to address that now. But just that I don't want to disperse it right away so they don't have a chance to file a mandamus. Mr. Cole, what do you think about that?
As we've said before, it's not really our dog in this fight. If the defendants want to assert their rights during that period of time, that would appear to be an appropriate time to either do so or ask the court for more time if it seemed they needed such.
Okay. Thank you, Mr. Cole.
Your Honor.
All right, Mr. West, get me an order on that.
I have one question. Sure. We still don't know how much money is out there. Okay, it was maybe, sort of, kind of, in terms of the response. And I mean,
Mr. Hurst, can you just email Mr. West the exact amount that you have frozen so that I don't need to be in the middle of this whole thing.
That's fine, Your Honor. I think we could certainly do that. I would ask this, Your Honor, and there are a couple things I'd like to put on the record just to make sure. Again, given that the defendants, as you've pointed out, are not appearing, even though they've got a counsel that wants to piecemeal appear, saying that they're only here to appear on appellate issues, but not wanting to insert themselves into the very to protect the record or participate in the very issues that are apparently going to be appealed. What has been conveyed to me numerous times in writing by Ms. Bone and Mr. Martin, and I think has been conveyed to others, is that they do not recognize this court or its court's orders. They think it's an illegal proceeding. They think that only the United Kingdom has jurisdiction over their copyright claims, and those threats have been levied certainly against my clients who are non-parties, but also, I believe, against the plaintiffs and perhaps even the court. So that's why I would reiterate and re-urge the objections that we had filed on April 19 and April 20th, respectively. I do believe that, Your Honor had, there's a briefing schedule set forth. The concern about the revenues and the distribution of those revenues at this point in time is that they could very well be part and parcel with what, Your Honor, we believe very orderly and correctly ordered, which is a briefing schedule to address the copyright issues. And those funds, unfortunately, I don't think are associated with the real estate. They're associated with the monies that have been generated through the video content on the YouTube channels. So the only other thing that I would ask is, to the extent that we're being required to deposit monies into the registry of the court, that we have been in the past or we are going to be in the future, I really kind of need to know what vehicle it is that those monies are being deposited. If it is a garnishment, even though it wasn't filed in a separate proceeding as required, and even though we're not a financial institution as set forth in the statute, before those monies are paid, the garnishee, i.e. Google, would be required to be paid by the movant, that is the plaintiffs, for the monies associated with the work that we've had to do to respond and to get involved with this. So I would ask that before there's any distribution of funds, that we be allowed to submit application for reimbursement of our fees associated with the exercise of doing what is in the nature or purported to be a garnishment.
Your Honor, may I respond?
Okay, briefly.
Oh, reasonable fees are okay, but sometimes you don't need 4 and 5 lawyers to do one thing. Secondly, there should be, even after the monies are distributed to us, there should be reasonable monies left to pay for reasonable fees. Secondly, Your Honor, you just put a 2-week window on paying the monies out of the registry to the plaintiffs. You signed an order on the 20th, giving the defendants 30 days from the 20th of April to deposit the additional $98,000 to the registry of the court to be paid to the plaintiffs. And so there may be a kind of, you may want to take a look at that to see whether or not you actually.
I had suggested originally that we do 30 days to let it all to be deposited. I thought you wanted to get the money out sooner. If you want.
No, we do. But again, you said pay to the registry of the court. I just want to make sure the court's aware that the other $98,000 needs to be.
It may not get paid within 14 days. I'm going to distribute whatever's in the registry of the court at that point, and then if there's more money that you need to get, then we can do an additional order. It's up to y'all how you want to do that.
Okay, you already have an order for that you've signed.
An order dispersing it or order depositing it?
Depositing it.
Yeah, so I'm saying that I'll sign an order dispersing it within 14 days, but it'll be just whatever's in the registry of the court.
Okay.
Does that make sense? So
it does, but you have monies. Let me just make sure I'm clear, and it may just be me. There's monies already in the registry of the court.
Right.
You said within 14 days you will sign an order distributing that money. The court has previously signed an order that says within 30 days that in order to make up the whole $389,000 that the Google is to put in $98,000 and $98,050.54 into the registry of the court to pay the full $389,000. You signed that back on April the 20th.
Right.
Okay, just want to make sure that everybody's on the same page. And I'll talk to Mike about getting all of
Mr.
it.
Capio, if you could get me that order distributed it with the new language in it as soon as possible.
You'll have it, Your Honor. Thank you.
And Your Honor, just to make clear, thank you, Your Honor. To make clear, whatever order Your Honor signs, will that actually go to the defendants and the lawyer that has made an appearance from Ms. Bone?
Mr. Capio, I want you to make sure you send a copy of that order to Ms. Bone, Mr. Martin, and their new possible lawyer.
Sure, I've been sending all the orders to them. I'll continue with the attorney.
Thank you, guys.
Okay, thank you, Your Honor.
Good to see you guys. Got to get to my next hearing. We've got a lot here today.
Thank you, Your Honor.
Okay. Ammo Incorporated versus Expansion Industries. Are both sides here on that?
Your Honor, we are here for Expansion Industries, Inc. This is Aaron Bogdanovich and Kathleen Cruz with my firm as well.
Your Honor,
Yes,
Andy,
Your Honor. Go ahead, Andy.
sorry about that. Your Honor, Andy Stinson and Brian Hale here for ammo, and I don't want to interrupt, but there's a couple preliminary matters I'd like to raise with the court.
Well, let's go on the record real quick. Tony, let's go on the record on DC 221704 Ammo Incorporated versus Expansion Industries LLC. Counsel, make your appearances.
Your Honor, Aaron Burke and Kathleen Cruz here with Burke Bogdanovich on behalf of Expansion Industries LLC.
Your Honor, Brian Hale here on behalf of Ammo Inc.
Your Honor, Andy Stinson here for Ammo Inc. as well.
Judge, this is Aaron Burke. What we filed here, we had on Friday an emergency hearing on a motion to dissolve the pre-judgment garnishment that was
We had a hearing on the motion to transfer this case to our court.
Correct, Your Honor. So the original, so what we had set was the emergency motion, and Your Honor was led to believe or under the impression that it was the motion to transfer, which you granted. And so we filed.
Have I signed that order yet?
Have you seen it, Ms. Cruz?
I think
We believe you've signed it. I think you ruled from the bench as well.
I just want to make sure I've signed it.
Okay.
Go ahead. I'll look that up right now while you're arguing.
Sure, Judge. And so what we're here about today is for, to the extent you did rule on the emergency motion to dissolve the garnishment, we filed an emergency motion to reconsider just because you had mentioned at the hearing to Ms. Cruz that you hadn't had an opportunity yet to actually look at the briefing from us. And I get it. It's an emergency motion and that's our fault. If anything.
I have signed the transfer order.
Okay, great. Thank you, Judge.
And
so what we wanted to touch on today is first, I think I told you this morning, and the reason for the evidentiary hearing is that although our client was not provided notice, once we file a motion to dissolve under the rules, that triggers the requirement for this hearing, which thank you, Judge, for making time on. And then it shifts the burden, and I think I told you this morning under Rule of Civil Procedure 664A, it shifts the burden to them. And the key language, and I won't waste your time by showing you the rule, but the key language of the rule under dissolution is once we filed the motion to dissolve, quote, the writ shall be dissolved unless at such hearing the plaintiff shall prove the grounds relied upon for its issuance, but the court may modify its previous order granting the writ and the writ issued pursuant thereto. And so, Judge, what we're asking here today is because one, without, although we didn't get notice, it is now their burden, since they went and got an ex parte garnishment in a second court for the same issues that are in front of you right now, is that it is now their job to show to you that the grounds that they attested to and signed a verification for are in fact true. And so the key one, and I think the easiest one for the court to look at today, is that they attested their CEO or president, I may be misquoting it, but their CEO of the company signed, and one of the requirements for the garnishment, and the key one here is that within the plaintiff's knowledge, that's ammo, the defendant does not possess property in Texas subject to execution sufficient to satisfy the debt. and let's even assuming there is a debt, which we do not and we disagree with, they attested to that. They have not provided any good faith basis that they've done as far as how they looked into whether there was any property in Texas subject to execution. But what we've provided the court is an affidavit from our client saying we own 197 acres or 100 and something acres. We own a multi-million-dollar manufacturing facility, and we own millions of dollars in equipment that they all own outright. And part of the most concerning thing to me, and I'm not casting aspersions on anyone here other than ammo, is that they were negotiating with the other attorney, the one who referred me this case. They were negotiating with my client Expansion to get a UCC lien on the very equipment that we've shown the court we have and we hold in Texas. So they've not shown the good faith or any good faith efforts to even investigate whether there is property. And now we've shown the court there is indeed property that's theoretically subject to
So did you guys agree to the lien or not?
No, Your Honor, we have not, because of the negotiations. They filed a breach of contract claim and a fraud claim and a theft act claim. And so we're in the process of negotiating with them, or the attorney who sent me the case was in the process of negotiating with them. Our position is there's no breach of contract. They did not pay. So the agreement was, we'll pay this amount for this many pieces of ammo. It's a primer. And our position is they didn't pay the amount. We informed them of that. Therefore, they need to pay the rest to get it. And so there's been no, and I touched on this a second ago, there's been no showing of debt, but over and beyond that, there's a reason why these garnishments are set up to place the burden on them for dissolution. It's because what's happened now is they've essentially gone down and got a traditional summary judgment in a different court that now they're for obvious reasons, putting the burden on us to try to prove the opposite of breach of contract. And so I think the rule 664A is clear. I think that unless they can show the court today that there is not a good faith basis for them believing there's not property that could be subject to execution, that the rule applies and it shall be dissolved. And then separately, Your Honor, I have with me.
You've already said all this, so let's hear from Mr. Stinson.
Your Honor, just thank you. Very briefly on the history, the hearing on Friday at 11 was noticed as an emergency motion to dissolve the writ of garnishment. That's why we attended Your Honor's office or court in person on Friday. The court heard arguments from both counsel, and the court very expressly said to defendant's counsel, we can recontinue this hearing, or I can make a ruling now based upon what I know. And a decision was made to end the hearing and for the court to rule. And obviously, defendant doesn't like how the court ruled on that, but the court ruled at that point. That ended the matter.
No, I mean, I think what I said was that if that I was going to transfer the case, that I wasn't ready to rule on the dissolution. I was just going to go based on, but if we rescheduled to Monday, that I would hear both sides. I don't think I ruled on this.
Your Honor, I
was leaning towards ruling on your favor, definitely on Friday, but
apologies, Your Honor, if I misunderstood. I thought we handed up to the court an order denying the emergency motion to dissolve. And I believe the court mentioned that it signed the order, and then it referenced on the order that it applied in both the court, the 68.
You're right. You were right. You were correct.
So the courts ruled on this. What was noticed for today, given that defendants didn't like that ruling that the court made, they noticed this as an emergency motion for reconsideration. And so, and now this is spun off into an evidentiary hearing, but they still, they didn't survive their burden. They're at the courthouse on Friday. They didn't survive their burden today when the emergency motion for reconsideration was held. They have since, Your Honor, approximately 1 hour before this hearing was rescheduled, filed a supplemental affidavit in an effort to cure defects that I raised with the court this morning with their affidavit. And so our position, Your Honor, is that they have not survived their burden to controvert our affidavit. AMMO testified that within its knowledge, it did not have knowledge of expansion having property in Texas subject to execution sufficient to satisfy the debt. And those two elements are very important. Their initial affidavit and really their second affidavit said evidences they have property in Texas, but neither there, you will find no comments, no representation or testimony in either affidavit that any of the property is subject to execution or that it's sufficient to satisfy the debt. That's missing from their original affidavit that was before the court on Friday. And it's even still missing from the court's record today after they've tried to cure that. They did provide a list of property, but it's still there's no evidence of sufficient property, and there's certainly no evidence countering or controverting my client's belief at the time, which that's the element of CPRC 6301. The element is within the plaintiff's knowledge, the defendant does not possess property in Texas subject to execution sufficient to satisfy the debt. And that was my client's firm belief at the time the application was filed, and it's still my client's belief, and they've not countered that, Your Honor. They've also, they reference property in Texas, but they've not sought to get a replevy bond. They've not sought any sort of replevy to make that property subject. In reality, Your Honor, they point to a piece of property in Bowie County wherein there is a $950,000 judgment lien against, and the property value in the appraisal district, and this is evidence they provide to the court today in their supplemental affidavit, the property value is still less than the amount that of the $2.25 million debt that's alleged in this case. And so one, the property, even absent a judgment lien, is not sufficient to satisfy the debt. Two, you have a $950,000 judgment lien filed against that property, which knocks the value down well below an amount sufficient to satisfy. Now, they do also provide a list of equipment that they purport to own without any sort of foundation of the value, but there's no evidence that there are not security interest, purchase money security interest attached to those equipment that apparently they've recently purchased. And so my client doesn't have knowledge that there's property in Texas subject to execution, and certainly not subject to execution in an amount to satisfy the debt. And their affidavits don't address that. So, Your Honor, we don't believe an evidentiary hearing is proper at this time, simply for the fact that they've not controverted the affidavit. The court's already heard these issues on Friday and issued a ruling, and they've still not overcome their burden in that regard. I also want to just briefly mention, Your Honor, reference to settlement, which, you know, I don't want to be ticky-tacking and object, but those are settlement discussions, and I think it's a little inappropriate to introduce as evidence or argument in a case settlement discussions. But secondly, yes, we did offer to settle for the full amount if they said we would have to release the garnished funds first. We said, well, we'll release the garnished funds because they needed time to pay, or approximately 30 days is what they said. We can pay in 30 days. Well, we've been waiting 10 months and haven't received any primers or any money. So my client is not willing to let go of the garnished funds because there's only $144,000 remaining in that account that was $2.25 million. And so we said, if you can give a security interest, we would then release the garnished funds, but not before then. And so nor was there any offer to give us a UCC, and because, Your Honor, we don't believe they have the ability to give us a first lien right on any property. It's either subject to a judgment lien or it's subject to some sort of other UCC. But the relevant fact here is my client doesn't have knowledge of their having property sufficient, and that's really what's at issue in this hearing, and they've not controverted that, Your Honor.
Your Honor, may I be heard?
You may.
Thank you, Judge. So, couple points. First, we are here today ready to present to you additional evidence. My client the president of Expansion Industries is on the line and standing by. That's the first item, to the extent the judge or the court wants to hear just about the property and the liens, et cetera. But two, the rule 664A does not say that I've got to disprove everything. I've got to show all the sufficiency. It says
665 or 664?
664, Your Honor, 664A. It says that I file the motion to dissolve, and then it becomes their burden. The plaintiff shall prove the grounds relied upon for its issuance, referring to the writ. Here, they have not brought anything to show you what grounds they relied upon. I don't have to prove his client didn't know it. His client has to come to you and prove what the grounds were they relied upon that led them to do that. But beyond that, Your Honor, I'd like to call Richard Smithson, the president of Expansion Industries, so he can tell you about the property. And I think
it says that the court's determination may be made upon the basis of affidavits, if incontroverted, setting forth such facts as would be admissible in evidence. Otherwise, the parties shall submit evidence. Why don't we do this? Why don't we, I don't have time to have an evidentiary hearing right now. So why don't we go ahead and have you guys take his deposition on this.
So Judge, I'm not meaning to cut you off if you were continuing there.
No, go ahead.
The real issue and crux of the matter is they garnished 2 employee payroll accounts, or an employee payroll account, which makes up the vast majority of the dollar figures. And if it does not get dissolved today, 4/26 is tomorrow is the day that those payroll accounts pay 65 employees. And if it is not lifted, then those 65 employees do not get a paycheck.
Surely they have other funds though, right?
Judge, we can ask my client, but I do not believe that there are any other funds that are subject that can be placed into into the payroll account, but I do not think there's any other funds available.
Well, then why wouldn't he agree to the lien then?
Because Judge, they've only filed a breach of contract case. I've litigated UCC liens sorry, Judge, for my tone. I've litigated UCC liens all over the United States. And if you want a UCC lien, you've got to prove there's a UCC lien and you have a right for a lien. Their contract for the payment that they made for the products that they were requesting provides no liens. Typically, if you want a lien on products or on property in a contract, you'd provide for that, but they haven't proved breach of contract. And that's ultimately why a prejudgment garnishment is such a problem here, especially when it's on an employee payroll account.
Your Honor, may be heard on that.
Sure.
There is no dispute in this case that my client sent to that bank account $2.25 million. There's also no dispute in this case, based upon the bank's answer, that there's only $144,000 approximately left in that account. That means over $2.1 million of my client's money that was, by admission of Mr. Smithson, held on deposit is gone. And it looks like the argument now is, Your Honor, we would like to spend the rest of their money on our payroll. I mentioned a case, Your Honor, and read you the holding at our hearing on Friday. It's Simulus versus GE Capital 276 Southwest 3rd 109, wherein the court held that the current wage exemption from garnishment did not exempt from garnishment funds in bank account that judgment debtor held to pay employees' wages. And so the amounts in an account are not exempt from execution. The court went to hold in that case. For example, Simulus may allocate other funds to pay those employees or may borrow funds to cover that amount. And so Your Honor is exactly correct. If they really do have other assets, or then certainly they can look elsewhere other than our monies that are still remaining on deposit to pay their payroll. And so it's the harsh reality of my folks is the fact that $2.1 million of their money is gone. And they've trapped $144,000, which we're just asking the court to hold and protect from their spending on their cost. during this litigation. That's the
Mr.
whole
Burke,
basis.
how do you distinguish that case?
Judge, I have not, since they have not responded to the motions, I've not had a chance to see that case yet. I'm happy to take a look at it and give you my view on it. I don't think we even get there. And candidly, the wages exemption, we can't find any case law on it. But that was our fourth, I think, point in the brief. Ultimately, what needs to happen here is the plaintiff, the ones who have garnished my client's accounts, needs to prove the grounds that they've relied upon. If they cannot or do not do that, we've heard attorney argument. If they can't or don't do that, the rule is clear, the writ shall be dissolved. And that's our position. And I'm happy to put our
Mr. Stimson, one last thing on that last point.
Your Honor, there's only allowed an evidentiary hearing if they controvert the affidavit, and they have not controverted
I get it.
the affidavit.
At this point, I'm not going to reconsider it. I'd be happy to allow you to take a deposition, Mr. Burke, or take a deposition of your client and submit that, have both sides have that opportunity, and then submit that to me so I can review it. But based on what I've seen, I'm not going to reconsider.
Your Honor, this is Brian Hill. If I could jump in one last thing, I think we also need to take the deposition of Mr. Smithson, since they presumably intend to call him. I can go run over to Mr. Burke's office so we can take his deposition.
Is that who we were talking? I thought that was who we were talking about. No, somebody else.
Judge, that's my client who's prepared to testify today.
Okay, yeah.
Yeah, that's who I was talking about. You should.
Okay, got it. I misunderstood what you're saying. I'll work with Mr. Burke on that. And it seems like also, Your Honor, I mean, if obviously I've got an affidavit which puts in what they want put in, as we all know, I was talking about my co-counsel. I mean, I've done a little bit of stuff in bankruptcy, and every bankruptcy I've ever been involved in, a company had millions in assets, sometimes hundreds of millions of assets. That's not really the question. The question is, do they have cash and do they have debt? So I think I need to get some basic financial documents. That's great. You got a piece of land worth $2 million. It doesn't make any difference at all if you have a $1.9 million mortgage on it. So I think we need to have a complete picture.
Why don't you guys do this? Why don't you figure out some kind of discovery schedule if you need to, if there needs to be a reconsideration motion on this to allow there to be some discovery on both sides. I'm happy to do that.
Okay.
I don't really want to try to decide it here on the fly.
That's fine. I know Mr. Burke. Will certainly cooperate and work with him on that.
And
thank you guys. You guys have a good day, and good luck with everything. Okay.
Thank you, Judge.
Judge, may I just ask, just very briefly, as I understand it, the court received no evidence from Ammo Inc. on this hearing about the dissolution.
Your Honor, the first hearing on Friday we were given notice of approximately 3 p.m. the day before the hearing, and then after that hearing, the emergency motion for reconsideration was filed, and we got notice of hearing again approximately 3 or so. This was last Friday, and the hearing was this morning, and then we got notice of this other hearing at that hearing. So we haven't had a chance, Your Honor, to brief anything. We can.
And Judge, I'm not asking about briefing. I'm just saying for the purpose of this evidentiary hearing, as I understand it.
So let me just say this. If you really want to insist on this, Mr. Burke, I'm happy to hold an evidentiary hearing. I don't have time today to do it. I could do that probably in about 3 to 4 weeks if you want to do one. I'm about to start a big, a multi-week asbestos trial. Right after that, I'm have another special setting. After that, I have another special setting. After that, I have another special setting. I don't have time for an evidentiary hearing right now. I'm not denying you the opportunity to do that. I don't believe the affidavit. I mean, the first issue is I don't believe the affidavit that was submitted was sufficient to even trigger one, but I do want to give you the opportunity to have an evidentiary hearing at some point. I just don't have time for it today. So if you still feel like that you want an evidentiary hearing, go ahead and contact the clerk's office and we'll be glad to consider that.
Okay. Thank you, Your Honor.
All right, guys. Thank you so much.
Thank you, Judge.
Okay. Our next hearing is David Jackson versus Preston Tower Condominium Association. Are both sides here on that?
Yes, Judge.
Yes, Your Honor.
Okay, Tony, let's go on the record on DC 1913360 Jackson v. Preston Tower Condominium Association. Counsel, make your appearance.
Nicole LaBeouf and Nathan Fort for David Jackson as trustee for the DRJ plan, plaintiff and movement.
Jim Sauter on behalf of Preston Tower.
And
Jim
Greg
Davis
Dodson
on
also on behalf of Preston Tower, Judge.
Yes.
Jim Davis on behalf of Intercity Investments.
Anyone else? Okay, you may proceed, Ms. LaBeouf.
Thank you, Judge. This is a pretty straightforward motion for summary judgment. We're moving on one thing only, and that is breach of contract and on the liability issue that the association is liable for breach of contract to Mr. Jackson, and that that Mr. Jackson is entitled to his attorney's fees for that breach. We have not moved for damages at this point, as that issue will be tried later. And we have not moved for a sum certain for attorney's fees. If I may share my screen, Judge, I'll take you quickly through the breach of contract and tell you what I believe is not disputed. All right. Are you able to see the?
I am.
All right, thank you. And so, Judge, what we have here is we turn to the declaration for the Preston Tower condominiums that defines the common elements to include the roof and the HVAC or air conditioning, as you can see here. And then we'd go to the bylaws, and the bylaws assume the same definitions that we saw in the declarations. So where we saw the common elements defined to include roof and HVAC, that carries over to the bylaws. The bylaws go into what the association through its board is responsible for, and that includes keeping in good order, condition, and repair the common elements, unless designated specifically to an owner. Then we look, Judge, here also in the bylaws, that one of the responsibilities of Part D of the board on behalf of the association is to obtain and maintain insurance covering at least the common elements. And for the protection, and you can see it here underlined in red, where the association is the attorney in fact or trustee for all the condominium owners. And when we look at the only insurance that the association is not responsible for, it's for damages inside the units not caused by the association's operation or maintenance of the project. And so if you'll recall, Judge, Mr. Jackson is here because he has a penthouse unit. The summary judgment evidence tells you he's 12 to 20 inches below a roof that has failed. It is such a mess that it constantly has standing water and puddles up at the top of the roof, and it's saturated. And so the reports that the association and its former general manager, ICI, put in front of you as summary judgment evidence tell you that that roof has failed and the roof needs to be replaced. And then the evidence before you tells you that there has been leak after leak in Mr. Jackson's condo unit, both from the HVAC, which is a common element, and from the roof, which is a common element. And Judge, you don't have to look just to our evidence. Mr. Kinahan, who operated as the general manager on site and was an ICI employee, filed an affidavit telling you that there were 6 calls about leaks after this roof was sealed in 2017. The sealant didn't work. And the PE from Hague Engineering that Mr. Sauter attached to his response confirms water damage and leaks. The only thing he contests is the extent of that damage. And Leslie Warren, the current president, her affidavit also before you in the association's response acknowledges the need for a roof replacement and states that that has been true since she assumed the presidency a year ago. The ICI exhibit in front of you from 4L Engineering places the blame for the failure of the HVAC on 8 or 9 different factors. And for all but one, that blame lies squarely with the association. The wrong filters, they don't have enough going on with the condensers when the weather changes. The condensation is accumulating in Mr. Jackson's condominium. So the only dispute that has been raised, Judge, is the extent of the damage. And that's not what's before you right now. If I may share again, I'm sorry, I was a little bit more from that.
So I apologize. Are both sides here for Mr. Wathen? Is your opposing counsel here?
Yes, Judge. Good afternoon.
And I think we have the juror here as well, ma'am. Is that AC and Nick? All right, I'm going to take you guys into I'm going to turn off YouTube and I'm going to take you guys into a